Professor Abrams.
Great, thank you so much, Beth, and I will attempt to share my screen, which hopefully has now happened. Great to speak to Penn Law alums. I've had many great conversations, and I hope to continue doing that, hopefully next year in person. But today we do what we can. Unfortunately, we've got the technology to do so. So I'm going to share some of my work in the past year about the impact of the pandemic on crime. And I'll just tell you a little over a year ago how this started. It was during the big first wave of the pandemic in the US. Cases were rapidly rising, and I saw a couple figures about the impact of the pandemic on crime and a couple types of crime in Philadelphia, and I saw big drops, and it made me wonder how widespread this was. Was this all types of crime? Was this a bunch of cities? Was this just Philadelphia? So I started looking for information on it. Now, normally I study crime as one of the major areas of my research, and usually I would wait 5 years for the FBI collects crime data from local police departments, aggregates it, and then I would get that data in 5 or 10 years. But this was something that was of major interest in a real-time way. And had it been a few years earlier, what I did wouldn't have been possible, because nowadays many large cities collect and disseminate crime statistics on their websites, on local websites in close to real time. And so what I did was I went out to try to see, had anyone aggregated this? Turns out no. But then went out and looked at and got data from these individual websites so that I could figure out whether this was what was happening broadly with crime. And one of the ancillary benefits of the project was I put together this data in a website, and you can see in the center here is sort of what the main page looks like. It's called citycrimestats.com. I'll put the link in the chat in a minute. You can click on it and play around with it if you want, but it shows data from the largest cities in the US on crime. It's got data that you can play with in a bunch of different ways. And it's been, we got some funding from the Quattrone Center at the law school. And so far it's been helpful, I think, to some other academics, as well as to the media. And we've gotten a bit of media coverage for it. So that was an ancillary unintended benefit, but let me tell you what I actually learned about crime and the pandemic onset. So I'm going to show you a figure that has a lot of what I learned in one picture. So this shows you overall crime incidents per capita, crime rates on the y-axis versus time versus month of the year on the x-axis. And it's got data for 2020 in red and the 5 prior years in gray. So what we can see straight off the bat is 2020 was very different from the prior years, where there's some seasonality to it. It rises, crime tends to rise in the summer, but otherwise it's relatively static. In 2020, there was a giant drop in crime right around the pandemic onset, and there was also this big blip in crime at the beginning of June. So let me first try to take a look at that blip in June. So that was shortly after the killing of George Floyd and the responses to it, the protests and also lootings. This corresponds largely to a big increase in burglaries around that time. So that's what that is. And you can see that crime rates rapidly return to the trend that they were on. This drop is the pandemic, and it was sharp, it was big, and you can see that it persists throughout the year. So even through, and this figure goes through October, but if you extend it through the end of the year, crime rates are still well below what they are in a typical year. And so after documenting this, next question is to try to understand what caused that big crime drop. So let me show you another figure that helps us understand that a bit. Now, instead of time in months, I have time on the x-axis relative to when a city put their stay-at-home order into place. And so this is right after it to the right and right before it to the left. And I've got two different kinds of data plotted on the y-axis. So the red line here, which is on the right axis, is mobility change. Mobility is a measure of how many people are on the street. It comes from cell phone data. The other data series is just the number of COVID cases. We can see COVID cases rose sharply right around when mobility dropped sharply in cities. And one interesting thing to note is that this all happened a little bit before stay-at-home orders went into place, about a couple weeks before stay-at-home orders went into place in the city. So mobility drop is a big piece of the explanation of why we saw such big crime drops. And here we can just look at one particular city, San Francisco, and now we've got mobility in red, big drop, and overall crime drop in blue in San Francisco versus time. This is from March of last year. And we see that these drops happen a couple weeks before stay-at-home orders went into place. So this is an interesting finding, I think, for people who care about the law, that the drops actually happened a bit before law changes. People were voting with their feet, essentially. People were changing their behavior, not because they were forced to, but because they were afraid of COVID. And that's what impacted crime. Many crimes need a victim for them to occur. If we think about robberies, if you think about assaults, if you think about theft from a person or theft from things left outside. All of these need people around. When people aren't around, the rates are going to decline. So that's the big reason for a lot of the crime decline. Let me show you a couple specific types of crimes that let me first summarize. So we had overall big drops in violent and property crime. The biggest drops were in drug crimes, 65% decline, and a number of large cities had overall crime drops of over 35%. So this is something that any police force wishes it could get to happen, but probably not in exchange for a pandemic. So a couple specific types of crimes that buck this overall trend of big decline. Burglary. So burglary, we have both residential burglary and non-residential. And here, oops, there we go. Here we've got it for Columbus, Ohio. Columbus saw a big drop in residential burglaries, but a big rise in non-residential burglaries. This makes sense. People start spending much more time at home. Those become less of an attractive target. Commercial establishments, now people are not there nearly as much. Those become a more attractive target. And we see this happening across almost all the cities examined. Increase in commercial burglaries, decrease in residential burglaries. Another type of crime that has gotten a lot of attention, especially in the second half of 2020 and into this year as well, is homicide as well as shootings. So homicide, this is now the period of time around the pandemic onset. So this only goes a couple months after the pandemic hit. So this is about through mid-May of last year, almost exactly a year ago. Homicides didn't drop like other types of crimes, but they didn't rise very much either. It was sort of a typical year for homicides during that time period. Same with shootings. They were up a little bit more than a normal year, but not a ton. And what we saw, if you looked at this later in 2020, second half of 2020 and continuing into 2021, we saw a big spike in homicides and shootings. And there have been a lot of discussion about this, why this happened. Is it because of the pandemic? Is it because of changes in policing or attitudes towards police? Any explanation for this has to also account for the fact that overall crime is still way down through the year of 2020 relative to a normal year. And so it doesn't yield an easy answer. Happy to discuss this more if people have questions about it. But it's a topic that people are still trying to figure out. So to wrap up, pandemic impacted crime in a big way. The biggest drops were in drug crimes, residential burglary, and theft. Most types of violent crime, and these are some of the cities that had the biggest drops in crime. We also saw increases in non-residential burglary and some car thefts as well. So I'm continuing to use the data from this that I collected for this to work on some new projects and some that are ongoing work that I've been doing for a number of years on race neutral policing, on effective police reform, and also on better understanding crime fundamentals using the unusual circumstance of last year to get some empirical purchase on it. Happy to talk about any of this as well. I think my time is up. Glad to have been able to speak to you today.
Thank you very much, Professor Abrams. That's really interesting data, and we look forward to finding out what you plan to do with it going forward. Let me just remind everybody that for those that are interested in CLE Credit, the code word is Philadelphia, and the link to the form is in the chat, so it should be easily accessible. And let me remind you that questions, we're going to have a question and answer session at the end, so if you want to put them into the chat now, feel free to do so. Great. Now, next we turn to Professor Tom Baker, and he is the William Mulnezy Professor of Law, and he's a highly regarded insurance expert and a leading scholar of insurance law and policy. And he's going to discuss how he will, how to gather information and use it as sort of a cluster of information to assess risk. So let's turn it over to Professor Baker.
Great. Well, thank you very much. First, Beth, give me a thumbs up if you can hear me. Great. Okay. So like David, I, at the beginning of the pandemic, was sitting there, paying attention to what was going on in my field. And what was going on in my field was, beginning in March of 2020, a huge number of lawsuits because businesses, most businesses have commercial property insurance of some sort, and commercial property insurance, as many people may know, includes business interruption coverage. And lots of people filed business interruption claims because their business was interrupted by COVID, and the insurance industry kind of across the board has denied those claims. And so then starting in March of 2020, there were an increasing number of lawsuits. And so I decided I was going to track them, in part as a way of dealing with my own COVID anxiety, but also I had been looking for an opportunity to see if it was possible to gather information real time about a set of litigation. A famous law professor, Mark Galanter, referred to them as case congregations. And so I thought, here's a case congregation that is starting, and can we track it in real time? And so over the summer, last summer, with a bunch of 1L students who were available because a lot of their internships had evaporated because of the pandemic, we built this plane as we were flying it. And then towards the end of the summer, we started releasing some of the information on a website. And this is a picture of the website, which is dynamically linked to the database. And we track a whole variety of things. The kind of killer app on the website has turned out to be that we started tracking who was winning at the sort of early stages of the litigation. And this page, there's, I have my Google Analytics for this page, and I can see that lots of people are citing it every day. And it's now, are looking at it every day, and it's been cited in the Wall Street Journal, New York Times, bunches of ABC News, the different places, and then it turns out that judicial, I can't say I'm sure the judges are looking at it, but certainly the judicial clerks are looking at it, and people are citing it in in their briefings as a way of sort of indicating, sort of how the, how these cases are going in litigation. So, so just, some things we're keeping track of. You can see that there was a huge increase in cases from a sort of baseline of 0, because there were no pandemic cases, and then a pretty, decline, and then a little bit of a blip at the end of the 1-year mark, and the 1-year mark reflects that some insurance policies had a provision that requires you to bring suit within a year of the loss in order to preserve your right to sue. And most of these cases are seeking this business interruption or business income loss, and we're tracking. There's a bunch of other things that people are seeking to. There's a little subset of cancellation policies, and even ski pass cancellation coverage. It turns out that's a thing, and there's an MDL about that. A significant number of the cases are brought as class actions, which isn't unusual for insurance. That there's plenty of insurance class actions, but it tends to be about things like the insurance company rounded up rather than rounding down when it was calculating a premium or violated some regulatory requirement. Whereas it's, people like me have always thought that lawsuits involving refusal to pay insurance claims of things like business income, where there's a lot of difference between the business income losses in different locations, would not be amenable to class. And we're not yet at the class certification stage in these cases, so I don't know if it will be successful, but that's one thing we're trying. And so here, here's in one place, one slide, what it is that we're collecting, and sort of an effort to articulate what's innovative about the project, which is, all of the data in the database is publicly available data, and much of it are things that you can get from other places too. And so, our contribution is really creating a single database that pulls cases from multiple sources, the most difficult of which are the state cases. And then, we identify what's important and, track them over time. And even, because of the publicness of the website now, I get real-time crowdsourcing of judicial rulings. We can set alerts and so forth to get the orders on a motion to dismiss or, summary judgment. And I have a student, I'm actually working with students both here and at University of Connecticut. And I have a student at University of Connecticut who deals with those alerts. And she and I have a little friendly competition about who finds out about the orders first. She by looking at the alerts, or me because 5 lawyers email me at 5 minutes after it comes out, so it gets counted on the tracker. And mostly I win. And it's not because of anything special about me. It's because that score sheet that we keep on the website is something that people are looking at and trying to influence. And then we have a whole variety of data that we're hand coding that isn't captured anywhere else. And those data are unique to this particular kind of case. And so this to Dissent that we're interested in trying to replicate this method for tracking case congregations in real time. The bottom half of the slide are things that would tend to be different for different categories of cases. And we're thinking, we're going to, in addition to sort of keeping up the COVID coverage litigation tracker this summer, we're going to be setting up a new set of cases to track. And right now, the leading candidate for that are the opioid liability cases. So that we'll do all the things on the top will be the same, but the things on the bottom half will be different for those cases. And why am I doing this? So two real big picture questions are, can you identify, track, and understand emerging case congregations in real time? And what does it mean to understand a group of cases as a congregation and to track them? And then secondly, this is part of our sort of public service part of, being a law professor in the United States in 2021 is, we want to try to provide objective, reliable information about the case. And so, and we've definitely succeeded in the second, and I think we've succeeded in the first. And I've got a few specific research questions that I'm be focusing on in the short term. I have real doubts about whether the federal courts are really following the Erie approach. Seems to me they're racing ahead and just doing a lot of guessing at state court and developing a kind of federal common law around here, which as an insurance law scholar is offensive to me. State, insurance law is, there's even a statute, the McCarran-Ferguson Act, that says that state law, state law is supposed to be preeminent or most important in the field of insurance. So I'm going to see to try to come up with a way of measuring whether judges are in fact doing that. And I welcome any insight that anyone has about what would be a good objective way of measuring that. The second thing is, any kind of case congregation, it's what makes a case congregation different than a case is a case congregation. The results of one case affect the other. And so it's a kind of iterative or Bayesian process. And so we're trying to figure out, well, so what are the events that cause people to update their understanding about the value of the case or what they should do with the case? And then we're, so one challenge is, can we identify those in close to real time and then also retroactively? And what does it mean then for it to be updated in that way? And then the second thing that I'm, just very early on is can we evaluate and update the evaluation of portfolios of cases? And by this, I mean literally value, like can you value them from sort of a litigation risk or financial risk perspective, and how do you do that? And then a final sort of ancillary but really important is that that we because these things do happen, and it's terrible to business when they do happen. We need some way of dealing with this in the future, and the private market is definitely not working, and it's not necessarily criticism of the private market. I'm not sure the private market could do this. And so I think this might be helpful for that. So here's just a couple more pictures in my few minutes that I have. This is a story that is emerging in the data is federalism. That it turns out that state and federal courts are treating these cases differently, which is very significant when you recognize that insurance law is state law. And so the big in federal court, mostly cases have been dismissed, those that have been brought for the order of motion to dismiss. I mean, now the insurance industry has been very clever, and I think chosen cases carefully of what they bring to dismiss. There's many cases where they've answered and not moved to dismiss. So anyway, so one big difference is, and then a second thing that is emerging is that here's another picture of the is that cases that there is a difference in the early resolution based on the quality of the contract, that where there is a virus exclusion, policyholders do worse than when there's not. And then, this is just a picture of showing that in state court, policyholders are actually winning when there's not virus exclusion, even though in federal court they're losing. And even when there is a virus exclusion in state court, policyholders are doing better than in the federal court. And that's significant. One of the people who've been tracking this are sort of investment people, and that they want to know like which insurance companies use virus exclusions and which didn't. And here's a little picture of that. Final tidbit before we go is that does it make a difference? One thing we're trying to figure out, hey, what makes a difference in how you do in court? Does it make a difference if you actually have some practical experience in relation to the field that you're litigating? And it turns out that there were a whole bunch of those early cases were filed by lawyers whose real expertise is class actions at MDL, sort of mass case. And it turns out those lawyers aren't as good, don't do as well as the lawyers who are experienced in have established commercial insurance coverage practice experience. And so is that because they picked better cases or because they do a better job with them? Who knows? Keep tuned. We'll give you an answer to that later. And then finally, I'm beyond my 10 minutes. David was so good at sticking to 10 minutes, so I'm not going to break the rule. I have some public policy implications that for another day. So let me stop sharing and look forward to questions.
Great, thank you, Professor Baker. Now I just want to remind everybody that if you would like CLE credit, again, you can go to the link that's in the chat and use the code word Philadelphia if you'd like to get credit for your attendance today. And then finally, we have Professor David Hoffman, and he is a professor of law in the law school that focuses on his research on contract law. He does empirical research in this area as well as theoretical work. He works in a very interdisciplinary vein. And today he's going to be discussing how COVID has affected contract law. And not for the first time has a pandemic done this. So I'll turn it over to Professor Hoffman.
Thank you so much, Professor Simmons. I'm going to share my screen and hopefully this will work okay. All right, so I really appreciate having the chance to talk with you all today about the role of disease in contract law over time. And so Professor Baker just gave you a real snapshot, database look at what's going on in litigation today. And I want to take us back about 100 years and look at a pandemic related, or at least epidemic related contract case of the past. And this came to me because last February, March, when we all went back into our houses, and I started reading a lot of law firm circulars. And the law firm circulars said, look, there's a lot of breached contracts out here. And what you really need to know in order to know whether you're going to win is you need to look at your contract and see what it says. See if you have the right exclusions in place, the right kind of impracticability clause, the right sort of force majeure clause, maybe as Tom suggested, the right kind of exclusions in your insurance policy. And that struck me as interesting, in part because one thing I teach my students is law is awfully indeterminate. Sometimes the things you write in your contracts don't quite work out. So I started doing research. Have we looked at this kind of problem before? Turns out we have. There's a great case that I found that has become a lot more popular cited of late, but until I started looking at it, it was not in any case book in the country, hadn't been cited in any of the law firm circulars. It's sort of been a forgotten part of the story of our commercial life. It's called Hanford versus Connecticut Fire Association. I'm going to give you a couple words about that before I give you a sense of the bigger project. So there used to be, and this is an amazing thing, there used to be a group of people who traveled around the country holding baby fairs. And baby fairs are basically a entertainment of the past where you exhibited babies. You would get prizes for the best baby, the most beautiful baby, the best disposition baby, the best dimples on the baby, the best brother and sister pair. And this was an entertainment, I guess, before Netflix. And it turns out one of the big providers of this entertainment was Babyland Amusement Company. This is actually a letter I managed to buy from Babyland Amusement Company, which they circulated in 1915 in Connecticut. What does the letter say? It says, hey, they're trying to get Danbury, Connecticut to sign up to the Baby Fair Consortium. And they say, look, we're actually going to be in the area because we're actually promoting the big show in Hartford, which is going to come soon. This is 1915. This is going to be the 1916 Hartford Baby Fair. And they tell you, look, baby is the biggest kind of drawing card, so you better get on the baby train now. It's an amazing piece of Americana. If you go look at old newspaper advertisements, you see them advertising, bring your baby, one and all. So look, it's a tragic story because it turns out the Connecticut polio epidemic of 1916 came. The first big polio epidemic in the country's history is Connecticut and New York. It eventually becomes more widespread. Enormous outbreak of disease, which of course disproportionately affects children. So the Connecticut Fair Association hears about this epidemic. It realizes there's suddenly an outbreak of disease. There is no public health guidance at this point. Nothing is shut down. We don't have shutdown orders that Professor Abrams talked about. All there is fear. So what does the Connecticut Fair Association do? It says, thanks, but no thanks. We don't want to have a baby fair. We're going to pass on the opportunity to bring a lot of babies into Hartford and exhibit them because of the prevalence of disease in the area. They don't have a theory about why it is that polio spreads. That comes later. They just know that it's outstanding. What does Babyland say? That's lovely. We appreciate your concern, but we would like to be paid our upfront fee, which is we were going to basically be paid to bring the babies to you so you could exhibit them. We were going to split the gate, but we would like our upfront fee, which is what the contract provides for. The contract specifically says basically a pay or play. Either you either you pay us our fee or we have to go away. And the Fair Association says, no. How about if we don't pay you and we don't have the fair? That's our counter proposal. So of course, Babyland sues. And they sue for breach of contract. They sue saying, look, and just to put it in modern parlance, there was nothing wrong with that contract when it was made. There's nothing impractical about the exchange. Your cost didn't go up in any meaningful way. It's not against public policy when the contract is made. There's nothing illegal about having a baby fair. In fact, it's delightful. There aren't even unconscionability arguments. You guys are big boys. You've made a deal. You ought to stick to it. There's no duress. There's no reason for you to breach apart from your own sense of increased social costs. Well, Connecticut Supreme Court hears this argument eventually. And what they say is, having the show under such circumstances would be bad public policy. Now, it could have been avoided had the plaintiff, Babyland, shown that there was really good, effective precautions in place to prevent communication of disease from one child to the other, or some other fact that made us sort of assured, but they didn't do so until therefore Babyland's going to lose. And here's the key part, and this is the part I think that actually has lessons for our life today. Court says we're not going to require the performance or award damages for the breach of a contract in which the public has so great an interest in the preservation of health, if health is in fact endangered. They basically say, even though the contract has a provision requiring payment, we're not going to enforce it under these circumstances. Now there's a dissent, quite pithy, as all of those old cases are. It says, don't we have like a Dr. Fauci for this purpose in Connecticut, who could tell us whether having a baby fair or not is a good idea? Why are we leaving this to a jury to decide whether it was a good idea or a bad idea to go forward with this fair? This is the kind of decision that should be left to the experts and the government regulators ex ante. A very, I think, familiar argument these days. So I took that case. I thought it was an amazing case. I was so happy when I found it. And I turned it with Professor Kathy Wong of the University of Virginia into an essay, which just came out last week in the Columbia Law Review called The Social Cost of Contract. And what we did was we basically tried to find other examples of moments in the history of contract law, and there are actually quite a few, where post-formation, the social costs of contracting skyrocket. Either there's epidemics or there's an undiscovered problem that causes health or potentially would cause health effects. And we try to look at what do courts do with these post-formation changes in the costs of contracting that the parties obviously have not accounted for. This is not the defense of impracticability. This is not the ordinary defense of unconscionability or public policy. This is something different. Now, there aren't a lot of these cases because thank God there haven't been that many epidemics. But there are some. So there are a lot of cases from the schools of 1870s to 1910. So cholera epidemic, yellow fever epidemic, lots of schools closed, teachers ask for payment, or school bus drivers ask for payment, or principals ask for payment, and the courts try to adjudicate those risks. There are a bunch of cases where there's construction hazards. They realize that they put together, for example, a stadium wrong, and it might have effects on the people who are going to be bystanders. And the question is, who has to deal with the costs of fixing that mistake? There are some cases about dangerous professions, a shocking number of ice road hauler cases in which basically ice road haulers saying, I can't go forward with a contract that's going to have an effect on human life that was unexpected at the time of formation. Can I get out? And then there's a bunch of cases about medical professionals who seek to breach their non-disclosure agreements because they think that failing to do so would harm their patients, particularly, I think, nurses who have done some bad things. And the question is whether the hospitals can disclose to a new employer what the nurse has done. And all of these cases, I mean, just to be honest, are a little bit of a mess. They're not particularly well reasoned by the courts, but there is a theme. And the theme is courts are pretty willing to reform and interpret contracts post-formation in order to save human life, or in order to save what they think is going to be, or reduce what they think is going to be risks to human life. Contractual risk allocations, ex-ante contractual risk allocations, like an act of God clause, or even like an explicit assumption of risk clause, are only going to mitigate that risk of judicial intervention. You can say that you are going to be entirely responsible for the following set of consequences. But my sense of the case law, and you can read the essay if you're interested, it's quite short, is that the case law doesn't really let you get off the hook simply because you say you're going to allocate risk in the contract. I think that the recommendation is going forward, parties ought to think about these sorts of social costs when they're contracting, try to think about the likelihood or the possibility of emergent risks to human health and life. And then also, and this is something Tom already mentioned, many of these cases, particularly the consumer cases, are going to be adjudicated in mass tribunals, MDLs, class actions, arbitral tribunals. And our view is that settlement's going to be the modal outcome. And so therefore, that's just another reason not to sort of rest so easily on your contracts themselves, because you're going to get something between what you bargained for and what the court's willing to give you. So we thought it was kind of a cool tour through history of contract law and disease. What I think comes out of that tour is contracts really don't work very well when the world's kind of burning. So I'm happy to take questions, and I obviously look forward to our discussion.
Great. Thank you very much, Professor Hoffman. And I think I might have put the wrong information. I said you can put the questions into the chat, but actually you can put them into the Q&A function. And it looks like Joanna Sachs has just done so. So she has the question, it looks like it's for Professor Hoffman. And it says, Professor Hoffman, can you tell me if you have looked at or considered the problem of traditional notions of assent at the time of contract formation, which holds you to the contract so long as it was properly formed? Professor Nancy Kim looks at this issue for contracts where people may change their minds, e.g. plastic surgery after the time of contract formation. Do we need to think about rethinking our notions of assent? Does this make sense? Here, parties or just a party may change their mind after assent due to public health crisis. How does contract law address this?
It's a great question. And so most of the sort of the litigated cases that I've been focusing on are ones in which both parties are essentially commercial entities, and they're assent-based arguments, which would typically be, I didn't really look at this particularly carefully. I was in a wrap contract. That was the contract of adhesion. Aren't going to work very well in these contexts. And that's sort of a feature, not a bug of American contract law. There's just not that many individual parties doing the litigating, given the stakes involved. I think that if you look at the way these cases are being talked about, the worry that courts have is that the "I changed my mind" argument is being used pretextually. They want to get out of an obligation, and they say, I feel terrible, I feel worried, I changed my mind. And the courts are going to be normally suspicious of that argument because it's awfully convenient to change your mind. And so what's needed is something more than my own sense of the risks of change. What's more is required is the courts agreeing that there is sort of an emergent risk to public health that the contractual enforcement would exacerbate. And the courts see themselves as sort of a backstop. Look, we didn't have an ex-ante regulation stopping this. We didn't have a government edict stopping this, but now the court's going to step in as sort of like the regulator of last resort. Now, this is a pretty uncomfortable position for courts to be in. It's naked judging in a way. There's no excuse for the political exercise here. But I don't think that they're saying, we want to validate changing your mind alone. I don't think they want to validate thinness of consent. I know Nancy's work. I really like it. But I think that these cases are really about a sort of a changing appreciation of a social, widely shared and emergent risk. And that's the focus that we tried to bring to the essay.
Very interesting. Okay, so any other questions that we have for our panelists? We have allocated 15 more minutes or so. So any questions?
So can I have a comment in response to David? So, one of the things that David's paper helps me articulate is why is it that I'm upset that the federal courts are racing ahead and making all these eerie guesses and not certifying questions to state Supreme Courts? It's because, our states differ in the degree to which they want judges involved in insurance regulation. And, whereas the federal courts are sort of uniformly taking a kind of like, just the facts, ma'am, I'm going to read the insurance policy and see what it says. And states really differ in the degree to which they do that, uniformly, and whether they would do it in a kind of special case like this. And it's, it's my intuition, and the question is going to be how to sort of figure that out, that a state court is going to be more willing to kind of make policy in that way than a federal court that's guessing about what a state court would do.
Great. we do have another question, and it comes from Craig Lord. And Craig Lord has a question for Professor Abrams, and he asks, have you attempted to detect any impact on crime of school closings, particularly in Philadelphia?
No, to answer that directly, but I can speculate because I'm a law professor. But what I can say is this: I think it's difficult to isolate the impact of school closings in the past year because they have gone along with so many other changes. Usually what we look for in trying to identify and trying to isolate a single cause of an impact, whether it's on crime or anything else, is some group that changes and some group that doesn't change, and ideally with some randomization. So if you think about a drug trial where you randomize who gets the new experimental vaccine and who gets the placebo, that's how we learn whether vaccines work. Same thing about any kind of social science question. Ideally, if there was some kind of randomization, obviously we wouldn't do it intentionally, but if there was some unintentional randomization, whether it's because of weather or sort of severity of impact of pandemic that causes some places to close schools and other places not, then we could have a pretty good comparison and say, okay, it looks like the difference is because of schooling, difference in crime rates. I don't think we've got that, at least not that I've seen. I haven't written about it, and I haven't seen anyone write about it in the past year in this scenario. Now, that being said, there's lots of speculation about the impact of school closings and whether that has had an impact. I mean, especially you hear people talking about this with increase in homicides and shootings in Philly. A lot of people saying like maybe that was a reason we started seeing a spike in Philly last year. So here are my counter arguments. So I'm suspicious of that. I think it could have an impact, but I don't think that's likely to be the sole or maybe even biggest one. The reasons why I don't think those are likely to have the biggest impacts, at least on homicides and shootings, are this. One, overall crime was still down a lot last year. And if we think that sort of kids being out of school and getting up to no good is going to lead to an uptick in crime, we'd expect to see an uptick. Two, the timing of the rise in homicides and shootings, it wasn't like when when schools closed in the spring. It was actually later in the year, sort of around when school usually gets out, early summer. That's when we first started seeing homicides and shootings in particular take off. I know you asked about crime in general, but this is a subset that gets a lot of focus. So the timing, I think, doesn't do it, and the sort of generality of the increase in crime doesn't do it either. That doesn't mean that this might not have had an impact. Probably did have a bit of an impact, but I don't think it's probably not the number one story on what caused the increase in homicides and shootings. And again, it's hard to sort of keep in mind as that's the emphasis. And Philly is not alone. A lot of big cities have seen this spike. It's hard to remember that overall crime was still down a lot last year, even as those really severe and important ones spiked. So that's my best guess. Again, I don't think there's a clear answer, at least not that I've seen.
Thank you. And let me remind everybody one more time of that code for continuing legal education credit, and that is the word Pennsylvania. The second code is Pennsylvania with a capital P. And we do have another question in the poll, in the Q&A, and it's from Joe Morrissey. And Joe has a question for Professor Baker. He asks, do insurance companies or plaintiffs' attorneys really have any systematic evaluation of the case other than putting fingers to the wind or counting others' wins and losses?
Well, legal reasoning is reasoning by analogy, as we, teach our first year students. And, in some cases, there are some prior cases that you can reason by analogy. There's a case where there was a construction project on a road that caused a deli to have a lot of dust and so forth in the building. And so does that, and the court in that case said there was no property damage because the business was able to keep going. There's a case in the Third Circuit in which there was a well that was contaminated by bacteria. And, the family said that the house was uninhabitable as a result. And the court said, okay, that is physical loss or damage, which is the operative term. But the prior precedents are few and far between, and none of them are, exactly like COVID. And in fact, we don't, the funny thing about these cases, this is one of my pet peeves about them, is that, we all think we know a lot about COVID. And so therefore you can I have some empathy for a federal judge who thinks that she or he really knows about COVID and therefore can make on a motion to dismiss what amounts to actually a factual determination and therefore dismiss the case. But, the science of, COVID is evolving. We were all, I'm sure we all remember wiping down the packages that came to the house at the first time. And, and the CDC was telling us, oh no, it's not transmitted by aerosols. Now, of course, we think it's transmitted by aerosols and we aren't wiping down packages anymore. So the answer is that courts largely don't know. And so therefore lawyers don't know. And so there is a tremendous bandwagon effect that's happening because and here I really credit the insurance industry with treating this as basically kind of like a mass tort and being very selective about which motions to dismiss they file and where, and getting a kind of the wind behind their sails. And so I think that helps explain what is going on. So anyway, the short answer to the question, I should have been like David, is no, but I'm a law professor, so I can speculate too. And but it does kind of get back to my theme about these cases is that I think they're being decided too quickly by the wrong according to the wrong standards and without sufficient deference to state law. And I will say this: in the Eastern District of Pennsylvania federal court, there's a couple judges that have remanded a bunch of these cases, saying that these are declaratory judgment actions, and declaratory judgment actions are the jurisdiction of diversity jurisdiction is discretionary. And interestingly, a bunch of those remand orders have been appealed, and the Third Circuit's going to be hearing consolidated appeal of that question, which is quite interesting, especially to those of us that care about insurance. Because I would be quite supportive of the idea of then remanding, because what these remand orders essentially say is, hey, there's not enough sufficient Pennsylvania law for us to decide. Let's remand it to the Pennsylvania court so we get an answer. And because in Pennsylvania, there's not the option of the district court certifying to the Pennsylvania Supreme Court. If you were in a state where there was an option to certify to the state Supreme Court, you could do that as an alternative to remand.
Thank you. And now we are back to crime for a minute. And Joe Morrissey has a question for Professor Abrams. It is, are drug crimes down because of lack of enforcement or fewer actual crimes?
Okay, so thanks for that. Thanks for the question. It was something I didn't get to talk about in the 10 minutes, and so I'll talk about it now. And I just put in to the Q&A. I don't know if that's the right place to put it, but I think it should show up in the answered. Yeah, part a link to. So I wrote a paper about this. It came out in the Journal of Public Economics last month, but you can get the preprint version, which is just as good if you want to read about it in more detail and if you like Greek letters and equations. But this question about like whether drugs, whether the decline in drugs is this because of decreased enforcement and also decreased reporting is an important one. Drugs, unlike most other types of crimes, our drug statistics come largely from police officer observation and reporting. Most other types of crime, we get information from reports from just normal citizens. And so if there's a change in police enforcement as the pandemic hit, or police sort of, dispersal, what they're doing, where they are, we'd think that could impact the drug numbers. That happened. We know that happened. A lot of cities announced they were doing that. Philly in particular did, and it was not alone that it was going to de-emphasize lower level crimes, specifically drug crimes, and that's almost certainly part of why drugs seem to show such a big decline. That being said, so then you might say, well, maybe that's all it was, and there was no actual decline in drugs, and how do we even know what the decline was in general? That's where I did a couple of exercises in the paper to try to look at pattern spatial distributions of crimes and how that varied during the pandemic, in particular looking at how distance from bars, so places that tend to have a fair amount of crime, how the distribution of crimes close to bars and far away from bars differed during the pandemic. Also looked at comparing drugs, which come largely from police officer reports versus other types of crimes that don't, how those varied before and after the pandemic hit. All this pointed to my best interpretation being that some of the effects, some of the decline is because of changes in reporting, but still the bulk of the decline, and this goes for drugs and everything else, is a real change that was brought on by the pandemic. So it's a great question, and it does say that the magnitudes of the decline that we measure they're wrong. They're not the true reduction in crime, but so the true reduction in crime is probably not as big as what's estimated, but it's probably not that far off from what we can measure.
Great, thank you very much. And one more reminder, the second code is Pennsylvania with a capital P for CLE Credit. Are there any other questions? If there are no other questions, and I certainly welcome some more, but if there are no other questions, I very quickly would like to just mention, because I'm just the chair, I'm not really a panelist, so I don't have my PowerPoints prepared, but I just wanted to mention, this is a global pandemic. It's a pandemic that involves countries from around the world. So I study public international law. And one of the very interesting things that I was thinking about is, how have states around the world responded to the fears about this pandemic? And one of the things that we had access to was a database on travel bans, as well as a database on internal restrictions about the use of face masks, shutdowns, closing schools, closing bars, etc. And so it raised this question, so what sorts of policies are countries putting into place in the face of this rather radical uncertainty about the transmission across countries? Now, my other work looks at the capability of states to have a presence at their international borders and to inspect entry and exit at their international borders. We use satellite images to come up with that measure. And one of the interesting things we found is that states that have already placed their assets to inspect who comes and who goes at their borders are, number one, much more likely to put travel bans into place than other states around the world. And number two, they're much more likely to keep them there for a long time. And number three, this is not true of internal measures. They are not more likely to have mask bans. In fact, they are less likely to, potentially. And it raises this really interesting set of questions around the choices states make about, should I sort of seal myself off from the rest of the world, externalize some of those adjustment costs, or should I bear a greater weight internally and require people domestically to stay home, to not go to school, to wear masks, and to take other so-called internal kinds of measures. And the interesting thing is states that already have the more restrictive structures in place prior to any evidence of any pandemic are the ones that make the interesting choice and potentially an interesting trade-off to close their borders and not take the more strict measures internally. So I just thought I would throw that out there too. And
Beth, I think you
Beth,
muted yourself.
Yeah, you muted.
was I muted that whole time? Good. So anyway, I just put my my paper into the chat as well, since we are putting in our links to our research as we go along. Terrific. Are there any other questions? Well then, thank you very much for joining us today. Thank you, Professor Baker, Professor Hoffman, and Professor Abrams. This has really been an interesting opportunity to hear what my colleagues are working on at this time. And again, I thank you all for joining us. I hope you all have a very nice day.